In this week's episode of the Crushing Debt Podcast, can a quitclaim deed and a quiet title lawsuit stop a foreclosure?
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
Welcome back to this week's episode of the Crushing Debt Podcast. I'm happy to say that our podcast is brought to you, is sponsored by Polly Bauer & Associates. Polly Bauer & Associates specializes in teaching you how to grow your business through the right payment methods, providing e-commerce education and expansion strategies, and educating you on the value of early detection and prevention of fraud. Learn more at www.polyabauer.com, and make sure to check out her brand new podcast, Swipe the Podcast with Polly B. So like I said in the introduction, this week's podcast episode is another listener question. A listener question about whether a quiet title lawsuit and a quitclaim deed can stop a foreclosure. And so here's a listener's question. If an owner in foreclosure quitclaims a deed to a non-family corporate third party, for example, a wholesaler, a subject to deed, to an investor, etc., does the recipient of that deed have any standing post-foreclosure, or do they have to quiet title to the deed? Fantastic question. Although I think the answer, unfortunately, is no. The short answer is no. Using this strategy probably will not result in a defeat of the foreclosure lawsuit. I think the bank's lien would still be superior, and I think the bank's lien would still foreclose out any subsequent owners of the property. And so to come to that conclusion, I first looked at two different Florida statutes. One is 695.11. 695.11 describes how we record documents in Florida, and it records and it describes where one document has priority over another. And it basically says the lower the number, the higher the priority. So when something is recorded, it's given a book number and a page number. So let's say the book number is 1,000 and the page number is 1. Well, then the next thing that's recorded is book number 1,000, page 2. Well, page 2 is higher, so page 1 would take priority over page 2. Now, you get into issues where documents are recorded months apart. You get into issues where there's documents, relating to different properties within that chain. But as a general proposition, what you're looking at is if you have a document recorded in book 1,000, page 1, and then something else affecting the property is recorded in book 1,100, page 1, well, your 1,000 book number is going to be lower, and so therefore it's going to be higher in priority. And so taking this example to the question, if I have a mortgage that's recorded in book 1,000, page 1, and the owner subsequently sells the property, and that quitclaim deed or warranty deed or whatever type of deed is recorded in book 1,100, page 1, well, that's a higher number, and so the mortgage is going to be superior, and so the mortgage is going to win. Now, what the statute says, the other statute that I want to reference here is 48.23, Florida Statute 48.23, and that deals with a lis pendens. Now, a lot of people think that when a lis pendens is filed, that's when the foreclosure is filed. And while that's true, you can use a lis pendens for other different types of lawsuits as long as that lawsuit affects title to real or personal property according to the statute. So, for example, you could see a lis pendens in a case where there is a quiet title action. You could see a lis pendens in a partition lawsuit. You could see a lis pendens in any lawsuit affecting title to real estate, not just a foreclosure. And so the other problem that is posed by this question, typically when the bank files its foreclosure lawsuit, they also file a lis pendens. And so if the lis pendens is recorded at book 1,000, page 1, and the quitclaim deed is recorded at book 1,100, page 1, or book 1,000, page 50, both of those are going to be higher and so lower in priority to the lis pendens that was recorded. And so when that judgment gets entered in the foreclosure case, the judgment is going to say this foreclosure affects anything subsequently recorded in the public records of the county that affects the title to the real estate. And the quitclaim deed is going to be inferior. It's going to be lesser in priority to either the mortgage and the lis pendens. And so therefore, that quitclaim deed, that new owner's interest in the property, will also get foreclosed by that foreclosure lawsuit. And so for this reason, I don't think it's a really good idea to try to do a quitclaim deed and then try to quiet title to the property. I think the bank is going to have a great defense that its mortgage is recorded, its mortgage is of public record, and so therefore the mortgage company is going to win. I've heard other investors talk about strategies where they deed the property into a limited liability company, deed multiple properties into the limited liability company. They give the owners of the properties some share of the limited liability company, presumably based on the value of their property that was deeded into the limited liability company. And then the limited liability company files bankruptcy, files a Chapter 11 bankruptcy with the effect of restructuring, or with the goal of restructuring all of the debt of the LLC, which is basically all of the different mortgages. I heard of this strategy a couple years ago. I don't know that I've seen anybody do it successfully. I don't think the bankruptcy courts are really keen on that argument. I don't think they're really keen on that type of a business structure. So if you're a real estate investor that's listening to this podcast, or if you're somebody who may be facing foreclosure that's listening to this podcast, and you get this great scheme of, well, deed the property to me and I'll make it better. I'll either put the property in an LLC, or I'll quiet title to the property, or I'll do something. If you're saying that, or if you're hearing that, that's a red flag that I would not advise trying to do. If you're a real estate investor, or if you're a homeowner and your property is in foreclosure or facing foreclosure, there are a whole bunch of other alternatives, all the way from a subject to transaction, where the investor takes title subject to the existing mortgage, with the caveat that the investor catches up the mortgage and makes payments on the mortgage. Now, the danger there to the homeowner is that if that investor ever becomes insolvent and stops making the mortgage payments, the mortgage company is going to come look to the homeowner to make up that money. So doing a deed subject to the original mortgage is dangerous for a homeowner that goes in uninformed. Another way to cure those issues are simply the loan modification route, the short sale route. There's also Chapter 13 that can help, a reorganization bankruptcy that can help in a situation like that. But unfortunately for this listener that asked this great question, I really don't think that this is a question that I can answer positively. I think if an investor takes title to a piece of property and then tries to quiet title to that property, I think they're going to be on the losing end of the argument when it goes up in front of the judge. So that's all for this week's episode of the Crushing Debt Podcast. Please reach out to me if you have a question that you want me to answer in a subsequent episode. Please reach out to me if you are someone facing foreclosure and you have questions about an investor that may have come and talked to you about acquiring your property, or call me if you're an investor that has questions about how to acquire distressed properties, how to acquire properties in foreclosure in such a way that it's a win-win for everybody. The borrower walks away, you walk away, everybody walks away, the bank walks away, all with a win. Thank you again to Polly Bauer and Associates, and take a listen to Swipe the Podcast with Polly B. And if you're interested maybe in contacting me about sponsoring the Crushing Debt Podcast, please give me a call. I would be open to having that conversation as well. So that's all for this week's episode. I do appreciate your listening, and I look forward to talking to you in next week's episode of the Crushing Debt Podcast.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.